Hello aspirants, welcome to Legal Cluster. Today we are going to discuss a very important topic for Assam Judicial Service, and that is dowry death under the BNS, that is Bharatiya Nyaya Sanhita. In this session we will discuss about what is dowry death, what are the essential ingredients of dowry death, meanings of some following terms such as dowry, cruelty, meaning of soon before death, etc., with relevant case laws. We will also discuss about reasonable time test, then we will know about punishment for dowry death, nature of death under dowry death, legislative intent behind dowry death law, presumption of dowry death, and burden of proof. So this session will completely make you understand on the topic in a very clear manner. At first we should know the meaning of dowry death. So section 80 of the Bharatiya Nyaya Sanhita defines the offence of dowry death and prescribes punishment for it. Dowry death is considered a grave social evil and offense not only against an individual woman but against society as a whole. The provision has been enacted with the object of curbing the growing menace of dowry-related deaths with a strong deterrent approach. Now let us know the essential ingredients of dowry death. We know that for an offense to be treated as dowry death, certain essential ingredients must be satisfied. Firstly, the death of a woman must be caused by burns, bodily injury, or must occur otherwise than under normal circumstances. Secondly, such death must have occurred within 7 years of her marriage. Thirdly, it must be shown that the woman was subjected to cruelty or harassment by her husband or any relative of her husband. Fourthly, such cruelty or harassment must be for or in connection with any demand for dowry. And lastly, the cruelty or harassment must have been inflicted upon her soon before her death. If any of these elements is missing, the offence of dowry death is not made out. So we have already come to know what is dowry death, but have we gone to the deep meaning of dowry? No, right? So the term dowry is not defined under the Bharatiya Nyaya Sanhita. The meaning is given to us by section 80 of the Dowry Prohibition Act 1961. It says that dowry means any property or valuable security given or agreed to be given directly or indirectly by one party to a marriage to the other party or by parents or relatives of either party at or before or at any time after marriage in connection with the marriage. However, you should note that dowry does not include meher in cases governed by Muslim personal law. Now let us know what does cruelty mean. Cruelty is defined in section 86 of the Bharatiya Nyaya Sanhita. Please remember that while you explain cruelty, you must mention a very landmark case, and the case is Shanti V State of Haryana of 1991. In this case, the Supreme Court held that the meaning of cruelty applicable to cruelty offences can also be applied to dowry death cases. Cruelty includes willful conduct of such nature as is likely to drive a woman to commit suicide or to cause grave injury or danger to life, as well as harassment with a view to coercing her or her relatives to meet unlawful demands for dowry. Now we will know the meaning of soon before death. The expression soon before death does not mean immediately before death. I am mentioning two law cases here. In Mustafa Shahadal Sheikh V State of Maharashtra of 2013, the Supreme Court held that there must be proximate and life link between the cruelty based on dowry demand and the death of the women. In Maya Devi v. State of Haryana of 2016, the court reiterated that the concept of proximity test is embedded in the expression soon before death and the time gap should not be too long. Here I like to mention two more case laws on reasonable time test of dowry death. In Girish Singh v. State of Uttarakhand 2019, the Supreme Court held that conviction under dowry death provisions can be sustained only when cruelty or harassment was for or in connection with demand for dowry and occurred soon before death. Further, in Ashok Kumar v. State of Haryana 2010, the court observed that the concept of reasonable time is the best criterion to determine whether the cruelty occurred soon before death. Okay, so let us know what can be the punishment for dowry death. The punishment prescribed under Section 80 of the Bharatiya Nyaya Sanhita is rigorous. A person found guilty of dowry death shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to imprisonment for life. The minimum sentence reflects the seriousness with which the legislature views this offence. Next important point is the nature of death under dowry death provision. In Maya Devi v. State of Haryana 2015, the Supreme Court clarified that dowry death is not dependent upon whether the death is homicidal, suicidal or accidental. If the death occurs otherwise than under normal circumstances and all the ingredients of Section 80 are satisfied, it shall be treated as dowry death irrespective of the nature of death. Thus, classification of death is irrelevant once statutory conditions are fulfilled. Next important point is legislative intent behind dowry death law. In Ajola Devi and ANR v. State of Jharkhand 2022, the Supreme Court emphasized that the legislative intent behind incorporating Section 80 BNS, earlier Section 304B IPC, is to deal sternly with the offence of dowry death. The court observed that dowry death is an offence against society and has a serious social impact. Therefore, courts must keep the deterrent purpose of the law in mind while averting punishment. So, what is the presumption of dowry death? To understand this point, we need to go through Section 80 and Section 118 of BNS. These two sections provides for a statutory presumption of dowry death. When it is shown that soon before her death a woman was subjected to cruelty or harassment for or in connection with demand for dowry, the court shall presume that such person has caused the dowry death. This presumption is mandatory in nature. Our last point is the laying of burden of proof. In Satbir Singh v. State of Haryana 2005, the Supreme Court held that once the prosecution is able to establish the essential ingredients of dowry death, the burden of proof shifts upon the accused. This shift occurs due to the statutory presumption under the law of evidence, and the accused must rebut the presumption by leading cogent evidence. That's all about dowry death law in India. I hope the video has provided you some important informations, and if yes, please do not forget to press a like for this session. We'll see you soon on my next session.